Welcome to EUPrivacyForAll, Session 8 on the published GDPR, Article 28, Processor. Article 26, debated during trialogue sessions, is now Article 20. It lays down that where the processing is to be carried out on behalf of the controller shall use only processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that the processing will meet the requirements of the regulation, but also ensure the protection of the rights of the data subject. On its side, the processor shall not engage another processor without prior specific or general written authorization of the controller. In the case of a general written authorization, the processor shall inform the controller on any intended changes concerning the addition or replacement of other processors, giving the controller the opportunity to object to such changes. Paragraph 3 of this article enhances the fact that the contract or legal act governing the relations between the processor and the controller is binding on both of them. This contract or other legal act shall stipulate that the processor processes the personal data only on documented instructions from the controller, including with regard to transfers of personal data. Ensures that persons authorized to process the personal data have committed to confidentiality. Takes all security measures required by Article 32 of the GDPR. Respects the conditions for engaging another processor. And taking into account the nature of the processing, assists the controller by appropriate technical and organizational measures, insofar as this is possible. It will also assist the controller in ensuring compliance with the obligations pursuant to Article 32 to 36 on security. At the choice of the controller, it will have to delete or return all personal data to the controller after the end of the provision of services related to the processing, and it will make available to the controller all information necessary to demonstrate compliance with the controller's obligations. As regards this last point, the processor shall immediately inform the controller if, in its opinion, an instruction infringes this regulation or a union or member state law. Where a processor engages another processor, the same data protection obligations will lay on this second processor, by way of a contract or another legal act, in order to implement appropriate technical and organizational measures. The initial processor will remain fully liable to the controller for the performance of that other processor's obligations. In order to demonstrate compliance, codes of conduct or certification mechanisms used by the processor could be put forward. Also, the fact that the contract or the legal act on which the controller-processor relation is based is in part based on standard contractual clauses could help demonstrate sufficient guarantees. The Commission may lay down standard contractual clauses for the matters referred in this article. A supervisory authority may also adopt standard contractual clauses. The contract or the legal act shall be in writing, including in electronic form. And without prejudice to other provisions laid down in Article 82 to 84, if a processor infringes the GDPR by determining the purposes and means of processing, the processor will have to be considered as a controller in respect of that processing. Other interesting provisions in the GDPR are laid down in Article 30 on records of processing activities, 84 on the evaluation of risks, Article 49 on the documentation of the assessment of data transfers, 32 on the security and the evaluation of risks, Recital 97 on the monitoring of internal compliance with the regulation, Article 48 on the use of international agreements to frame data transfers in the frame of law enforcement requests, Article 37.4 on the designation of a data protection officer, or again Article 82 on the obligation to compensate data subjects for any damage suffered. Currently, the directive lays down in Article 2a the definition of a processor, that is to say, a natural or legal person, public authority agency, or any other body which processes personal data on behalf of the controller. Article 16 lays down a confidentiality obligation. Any person acting under the authority of the controller or of the processor, including the processor himself, must not process them, the data, except on instructions from the controller. Article 17 on the security of processing sets that the controller shall choose a processor providing sufficient guarantees in respect of the technical security measures and organizational measures. The carrying out of processing by way of a processor must also be governed by a contract or legal act binding the processor to the controller. What should accountable data processors get prepared for? First, they should document appropriate technical and organizational measures, the so-called TOMs. They should refrain from engaging another processor without the prior specific or general written consent of the controller. They should get a contract or other legal act ready to frame each processing activity. They should also know that there will be qualifying as a controller when determining purposes and means for brand new processing. They should document the instructions from the controller, including with regard to transfers of personal data. They have the obligation to share information and assist the controller with regard to demonstrating its own compliance with GDPR. They shall review and update the measures taken whenever necessary. They also have to promote the addition to non-binding tools such as codes of conduct and certification mechanisms, and will have to implement lots of other steps in order to demonstrate that they meet the obligations under the GDPR, such as keeping track of their processing activities in dedicated records. So the question now is knowing how this documentation of accountability will be framed by the upcoming European Data Protection Board.